Good day, everyone. The case is Ronaldo Belen versus People of the Philippines, GR number 211120, February 13, 2017. This is under Article 354, Requirement for Publicity. The facts of the case are as follows. On March 12, 2004, petitioner, then a practicing lawyer and now a former judge, filed a criminal complaint for estafa against his uncle, Mr. De Belen Sr., before the office of the City Prosecutor of San Pablo City and assigned to then Assistant City Prosecutor Maria Victoria Sofia Galagman for preliminary investigation. With the submission of the parties and their respective witnesses' affidavits, the case was submitted for resolution. In order to afford himself the opportunity to fully present his cause, petitioner requested for a clarificatory hearing. Without acting on the request, Assistant City Prosecutor Sofia Galagman dismissed petitioner's complaint. Aggrieved by the dismissal of his complaint, petitioner filed an omnibus motion for reconsideration and discussion. On September 20, 2004, Assistant City Prosecutor Sofia Galagman filed against petitioner a criminal complaint for libel on the basis of the allegations in the omnibus motion. It was alleged that the omnibus motion had for its subject to appear and made it understood, as was in effect understood and interpreted by the public or persons who read it, that Maria Victoria Sofia Galagman is an inept, ignorant, dishonest, corrupt, undeserving, unjust, unfair, and incompetent prosecutor of the office of the City Prosecutor of San Pablo City. The trial court found petitioner guilty of libel, which the CA affirmed. The issue of the case is whether or not the CA erred in finding the petitioner guilty of libel despite the absence of the element of publication. The Supreme Court ruled that the petition lacks merit. Publication in libel means making the defamatory matter, after it has been written, known to someone other than the person to whom it has been written. A communication of the defamatory matter to the person defamed alone cannot injure his reputation, though it may wound his self-esteem, for a man's reputation is not the good opinion he has of himself, but the estimation in which others hold him. In the same vein, a defamatory letter contained in a closed envelope addressed to another constitutes sufficient publication if the offender parted with its possession in such a way that it can be read by a person other than the offended party. If a sender of a libelous communication knows or has good reasons to believe that it will be intercepted before reaching the person defamed, there is sufficient publication. The publication of a libel, however, should not be presumed from the fact that the immediate control thereof is parted with unless it appears that there is reasonable probability that it is hereby exposed to be read or seen by third persons. In claiming that he did not intend to expose the omnibus motion to third persons, but only complied with the law on how service and filing of pleading should be done, petitioner considered that the defamatory statements in it were made known to someone other than the person to whom it has been written. Despite the fact that the motion was contained in sealed envelopes, it is not unreasonable to expect that persons other than the one defamed would be able to read the defamatory statements in it, precisely because they were filed with the office of the City Prosecutor of San Pablo City and copy furnished to Nizar, the respondent in the estafa complaint, and the office of the Secretary of Justice in Manila. Then, being a lawyer, petitioner is well aware that such motion is not a mere private communication, but forms part of public record when filed with a government office. Inasmuch as one is disputably presumed to intend the natural and probable consequence of his act, petitioner cannot brush aside the logical outcome of the filing and service of his omnibus motion. Thank you for listening.